Okay, thank you very much. And we're going to go ahead and get started. As she mentioned, we'll be taking any questions towards the end of the presentation as well. So feel free to send those throughout the presentation and we'll answer those. So as she said, we had a guest speaker today. I'm happy that Jared Sharp, FEWA's General Counsel, is also able to join us. He is responsible for advising the association and its staff in legal matters, as well as staying current on legislative and regulatory issues that could impact FEWA members. He has been involved in presenting various educational programs, including webinars like today and conference speaking engagements and writing articles as well. I'm going to be your host today, Arnulfo Hinojosa. I'm Vice President for the FEWA. I've been approved by the U.S. Department of Justice Board of Immigration Appeals as an accredited representative for FEWA Foundation. This designation takes in consideration my experience and knowledge of immigration law and procedure, and it authorizes myself to practice before the Department of Homeland Security. So I want to thank you for joining us today. We have a very important topic to discuss on how to employ legal temporary labor. The Federation of Employers and Workers of America, FEWA, is a national nonprofit association that consists of employers across the country that we help utilize the temporary guest worker programs H-2A and H-2B. In the time allotted today in today's presentation, we do not expect you to memorize all the regulations. We simply want them to be on your radar so you are prepared to ask the correct questions. If you are currently utilizing the H-2A process and have a case-specific question, please follow up with us after the presentation. We'd be happy to discuss the specifics regarding your program. At the end of the presentation, we'll be have our direct contact information up for you. I will begin by walking us through some of the basics of the H-2A program. Jared will be covering the concepts, obligations, assurances, and enforcement later in the presentation. To get started, we would like to remind everyone that the materials in this presentation are general in nature and are for informational purposes only. They are not offered for and do not constitute specific legal advice. Nothing provided within this presentation should be used as a substitute for the advice of your own independent counsel. So with that, let's get started. Today we'll be focusing on some of the most important requirements of the H-2A program. It's important to remember that just the Department of Labor regulations by themselves are almost 30 pages long. Beyond that, there are the U.S. Citizenship and Immigration Service regulations, the Department of State guidelines, and so forth and so on. We'll not be covering many of those items, but instead, in the interest of time, we'll be reviewing the summary documents that the Department of Labor has made available. There is a citation list near the end of the presentation where these documents can be found. So what is the H-2A program? The H-2A program is authorized under the Immigration and Nationality Act and allows a U.S. employer to hire foreign workers on a temporary basis to perform agricultural work where there are not sufficient U.S. workers available. We will discuss more on what is required to prove that there are not enough U.S. workers available to you. In order to participate, the U.S. employer must have full-time work that needs to be performed on a temporary seasonal basis. Employer must have a physical place of business in the United States, have a federal employer identification number, and ability to hire, pay, fire, supervise, or otherwise control the work of the workers employed. The work must consist of agricultural labor or services such as planting, raising, cultivating, harvesting, or production of any agricultural or horticultural commodity. The work must be full-time, which is described as at least 35 hours per week. The work must be seasonal or temporary in nature and tied to a certain time of the year by recurring events or pattern, such as an annual growing cycle, normally lasting 10 months or less. The qualifications that you specify the job entails do not substantially deviate from the normal and accepted qualifications required by non-H-2A employers in the same or comparable occupations and crops. There are 4 main filing agencies involved and 1 primary enforcement agency, which, as you can imagine, creates a lot of red tape with that much bureaucracy involved. The first agency we'll be working with is the State Workforce Agency. We'll be referencing SWA throughout the presentation here, which stands for the State Workforce Agency. They assist with the processing of the agricultural job order and with U.S. worker recruitment. The U.S. Department of Labor must issue a certification indicating that qualified U.S. workers are not available for the job, and the employment of temporary foreign workers will not adversely affect the wages and working conditions of U.S. workers similarly employed. The U.S. Department of Labor has a set of filing fees that consist of $100 per application and $10 per worker with a maximum of $1,000. The U.S. Citizenship and Immigration Service must then approve a visa petition. The USCIS has filing fees of $460 filing fee and a $100 fraud prevention fee, which totals $610. This fee is not a per worker fee. The U.S. Department of State, through U.S. consulates abroad, screen the individual workers and issue visas for applicable workers. The U.S. Department of Labor Wage and Hour Division enforces the terms and conditions of the worker protections under the H-2A program. Some of the basic process elements of the program include the agricultural job order request must be filed with the SWA no more than 75 calendar days and no less than 60 calendar days before the date of need. The employer application packages are submitted to the U.S. Department of Labor at least 45 calendar days before the date of need. USCIS and individual workers processing at consular locations will have their own applications to submit to the U.S. consulate abroad. And the recruitment of U.S. workers through the job order, newspaper advertisements, and reporting to the U.S. Department of Labor on the results of recruitment. So we included a chart here that the Department of Labor provides that gives you an idea of the numerous steps involved to navigate the filing agency process. I understand you may not be able to read the specifics in this chart, but this just gives you an idea of all the different steps that are involved and what different areas that you could be responsible in. So with that, I'm going to turn things over to Jared. He's going to cover the concepts, obligations, assurances, and enforcement.
Thank you, Arnulfo, and good morning, everyone. So I know time is short this morning, so we're going to just jump right in and look over some of these concepts, obligations, assurances, and enforcement related to the H-2A program. We're going to encounter the term corresponding employment, and so let's look at what that means. Basically, for an H-2A employer, the Department of Labor regulations also apply to those U.S. workers who are performing the same H-2A job duties or in other agricultural work that the H-2A workers are doing during the period of need. H-2A workers can't receive preferential treatment. U.S. workers have to receive the same working conditions and terms as the H-2A workers. The job opportunity must be open to U.S. workers regardless of citizenship, race, color, national origin, age, sex, religion, and handicap. And the U.S. workers can only be rejected for lawful job-related reasons. And the employer must keep records of all rejections. Employers have to accept Department of Labor referrals for U.S. workers and provide employment to any qualified U.S. worker who applies for the job until 50% of the work period has passed. This is the reason that employers have to keep their recruitment report open until after that point. For layoffs and U.S. worker displacement, the employer isn't going to be laying off U.S. workers within 60 days of the date of need, except where they've offered the job to U.S. workers first before hiring any H-2A workers. If a layoff occurred during the work period, H-2A workers would all have to be laid off before any corresponding U.S. workers. Employers are only able to reject U.S. workers where there is a lawful job-related reason. For the payment of the required wage, the highest rate must be paid that is in effect at the time the work is performed. Typically, this is the adverse effect wage rate, or AWR. But as state minimum wages increase, this is an area to watch as well, especially in the northwest part of the country. A good way to keep engaged with your state on this and other important state issues is through participation in your state associations. If a new AWR rate is published, or the employer is notified during the contract period, and that rate is higher than the original wage, the employer will have to increase the pay of all the employees. The wages can be calculated on an hourly rate or a piece rate as the employer specifies in their application. Per pay period, piece rates must average no less than the highest required hourly wage rate. As a result, a piece rate is never going to drop a worker below what they would have made hourly. The worker must be guaranteed a total number of hours of at least 3/4 of the workdays in the contract period. The calculation begins on the first workday after the worker arrives, or the contracted first date, whichever is later, and ends the day the contract expires. Each workday consists of the number of hours specified in the job order. Failure to meet the required hours would require the employer to supplement the worker's pay to meet the 3/4 guarantee. There is an exception where a worker is displaced due to a U.S. worker referral, where a worker voluntarily leaves, or where they are terminated with cause, and the employer notifies the government of his or her separation. A really important part of this, which also factors into audits by the Wage and Hour Division, is that employers must keep records of hours offered each day and the hours actually worked each day. Let's take a look at a specific example that the Department of Labor provides illustrating that 3/4 guarantee. If a contract is for a 10-week period during which a normal work week is specified as 6 days a week, 8 hours per day, the worker would need to be guaranteed employment for at least 360 hours. We arrive at that number by multiplying the length of the contract by the number of hours in a week, which would be 10 weeks times 48 hours per week equals 480 hours, multiplied by 3/4 or 75% equals 360 hours. The employer must provide or pay for transportation and daily subsistence costs to the place of employment or reimburse workers once 50% of the contract work period has elapsed. While this is the baseline standard outlined in the regulations, the Department of Labor interprets these costs, or has interpreted these costs, along with the visa consular appointment scheduling costs, to be for the benefit of the employer in the H-2 context. As a consequence, the DOL will want employers to reimburse these costs, if they didn't pay them initially, where the total of those costs would reduce a worker below federal minimum wage in the first work week. For the purposes of this general information session, just know that this has been a litigious area and there's quite a bit of case law out there on this particular issue. So to wrap this up on this slide, there's also a requirement to provide or pay for return transportation and daily meals upon completion of the work contract. In addition, transportation must be provided to and from the work site and the employer provided housing at no additional cost to the worker. An employer must comply with all applicable laws and regulations, be properly insured, and the offered transportation must be operated by licensed drivers. Housing must be provided at no cost to H-2A workers and those workers in corresponding employment who are not reasonably able to return to their residence within the same day. Housing is inspected by the State Workforce Agency, and it must be maintained during the occupancy to continue to meet the standards. Failure to provide compliant housing may result in revocation of an existing labor certification. For rental and public accommodations, they must meet local standards. Housing-related charges must be paid directly by the employer to the housing's management. If certified housing becomes unavailable, substitute housing must still be in compliance with the applicable housing standards. The employer must provide 3 meals per day to each worker at no more than a Department of Labor specified cost, or the employer must furnish free and convenient cooking and kitchen facilities where workers can prepare their own meals. A copy of a work contract must be provided to each worker. This must happen no later than the time at which the H-2A worker applies for a visa, and for a U.S. corresponding worker, no later than the first day of work. It must also be in a language understood by the worker. An employer must specify in the work contract all deductions which are not required by law, which will be made during the period. If it is undisclosed, it is impermissible. The amount of any deduction must be reasonable, and an example that the Department of Labor provides is that it would not include a profit to an employer. Employers' attorney fees, application fees, and recruitment costs, tools, supplies, and equipment required, housing, daily transportation to and from the fields, and employer-provided housing are specifically prohibited from being deducted. The employer must notify the Department of Labor and the Department of Homeland Security within 2 working days regarding voluntary abandonment of employment or termination for cause of an H-2A worker. The employer needs to notify the DOL where it is a U.S. worker in corresponding employment that is involved in the separation. What is considered abandonment? The failure to report for work for 5 consecutive working days without the consent of the employer. Employers who provide timely notice are not obligated to meet the 3/4 guarantee or provide return transportation for such workers. However, caution on this note, be careful of the FLSA interpretation that we mentioned earlier, that in other visa contexts, the Department of Labor has issued memos with interpretation guidance stating that transportation costs are the responsibility of the employer, and that those costs can't drop below minimum wage, FLSA minimum wage, for return transportation as well. Regarding the notice of worker rights, a poster must be obtained from the Department of Labor. This poster must be posted in English and in another language as necessary, and posted in a conspicuous location where employees can readily see it. Employers must provide state workers' compensation insurance at no cost to the worker. Employers must also furnish an hours and earnings statement to each worker each payday, which must be at least twice monthly. On the hours and earnings statement, just to give you an idea of what would be included on that, hours offered, hours actually worked, hourly rate, and total earnings for the pay period, deductions from wages, and if piece rates are used, the piece rate of pay and the units produced daily. The employer must also provide all tools, supplies, and equipment required to perform the assigned duties at no cost to the worker. The employer and its agents will not seek money or other kickbacks like in-kind payments, free labor, etc., from the H-2A worker for reimbursement for costs related to obtaining labor certification.
No, I'm just listening.
The employer will contractually forbid international recruiters to seek payments from employees. Employer won't retaliate against an employee filing a complaint, consulting with an attorney, or exercising another protected right. There are additional requirements for labor contractors that we're not going to be covering in detail today. Just know that there are provisions that do apply specifically for labor contractors, and they do have additional obligations and requirements.
I think we. Sorry, I don't
records
mute this.
Records and documents must be retained for a period of 3 years from the date of determination. The date of determination would typically be the date of certification or denial. Examples would include job order, advertisements. On those advertisements, it would be both the local and other state advertisements, contact with former U.S. workers, final recruitment report, and resumes and contact information for U.S. worker applicants. In addition, workers' compensation insurance proof, workers' earnings records, and the work contract. Often, employers end up keeping an audit file on hand with their H-2A application information in the event of either a paper audit or a walk-in audit performed by the Wage and Hour Division. Speaking of the Wage and Hour Division, the DOL Wage and Hour Division can conduct investigations, impose penalties, debar employers from future certification, recommend revocation of existing certifications, and seek injunctive relief and specific performance of contractual obligations. And this is a list of citations that we referenced earlier, with some of those links to the Department of Labor guidance that was covered today in this presentation. And with that, we will open the floor up for questions.